This is Attorney Christopher Ripley. I am an attorney with CCSK Law. Let's talk about some common pitfalls in applying for Medicaid or the Medicaid planning process. And there are several. The first one that I'm going to highlight is really kind of a more modern, although, it's a periodic concern, and that is just the Medicaid process and system itself. Over the last, say, 30 years, Indiana Medicaid has evolved structurally and procedurally in a lot of different ways. And frankly, the state has tried different things, from using third-party contractors to changing provisions of the Medicaid manual to shifting case management from a centralized center to the regions or the reverse. And this has created a lot of changes in the process over the years. Behind the scenes, Medicaid caseworkers are required to work with a variety of computer programs that manage different parts of the process. There have been some attempts to kind of consolidate and streamline, but every time you implement a new program, it creates new points of failure and new difficulties and new delays. Most recently, the introduction of the AVS, the Asset Verification System, over this last summer has certainly created additional delays in case processing and generated some odd results that then need to be navigated through by either facilities, families, or their attorneys. And so I'd say that is really our first pitfall. Expecting that the process is going to be necessarily straightforward, and even these days necessarily as quick as the statutes would normally require on paper. Our next pitfall is really just not being prepared to timely provide all of the necessary information. A Medicaid application requires the family to turn in a substantial amount of documentation. And this can vary. A small application might be a few dozen pages. A larger application might be, easily up around 100 pages. My personal largest application involved a medical review, and we were probably up around 500 pages. That's not usual, but I would say normal applications in my office clock in at about 100 to 150 pages. That's a lot of documentation for a family member to put together, especially if there's a crisis and their loved one is, say, in a facility or hospital. They want to be spending time with that loved one rather than running to the bank or fighting with insurance companies to get paper. And so that time crunch is its next pitfall. We really address that by trying to get out ahead of time. If we can do some planning up front and maybe 6 months or a year prior, start collecting these documents and storing them in a safe place, if they are needed, they're ready. Now, some of these may need to be updated, get a new annual life insurance policy statement, get updated bank records, but a house deed isn't going to change, vehicle title information likely isn't going to change, identifying documents aren't going to change very often, and so having those ready and waiting avoids some of that work if a crisis should arise. The next major pitfall that I would want to focus on is failing to report information. There's a difference between just not getting documents in time and, say, deliberately hiding information. We don't want to hide anything from the state of Indiana, and particularly with the kind of systems that they have, families are going to be less and less able to do that, and as an attorney, I'm ethically bound to present, full, accurate, and truthful information, to the state of Indiana, and so I'm certainly not going to be a part of that. But that, in and of itself, is a flag for practitioners that something else is going on. Maybe a family member has done some things that they're not proud of, or there are transfers that we don't want to talk about. All of that sunlight's going to have to come in, and the way to get around that is, frankly, just to have that full, frank, and honest conversation up front. Many of those issues are things that can be navigated through the process if the attorney knows about them up front. The last major pitfall that we want to talk about is, again, not necessarily a pitfall, but something we just need to work around, and that is transfers. The Medicaid application process penalizes certain transfers with some exceptions for less than fair market value. Basically, you can't give all of your stuff away on day one and then on day two expect to be able to apply for Medicaid without there being adverse consequences to your eligibility. Here, the solution really is, again, to have that full, open, and honest conversation, disclose transfers, plan around them, and if there need to be some transfers or purchases, talk with your attorney first. plan before acting. Talk, get that plan together before you go off and do things. It's much easier to put all of the pieces in place beforehand than, if I get a call, a week after a transfer has happened and then get the question, is this okay? Maybe it is, maybe it isn't. Maybe it's reversible, maybe it's not. So we want to be very careful about that part of the planning process as well. And if you do that, you get out ahead, you can avoid each of these pitfalls as you work through. If you'd like more information or have any questions, please don't hesitate to contact us at CCSK Law, 57 Michigan Avenue, Suite 101, here in Valparaiso, Indiana, 46383, or give us a call at 219-230-3600. Check us out on the website at ccskallaw.com.